Yes, have you got some, have you?
I'm currently in the situation where I don't know what I don't know. So
oh, that's
once
good.
I've got an inkling as to what I don't know, then I'll probably have some questions.
Okay.
Yeah. We'll get there, I'm sure.
We will, we will. Alrighty.
Okay.
Oh.
Oh, what?
How did that end up on there, the NAR Harcourts?
Oh, we're taking that off?
Yeah.
Okay. Easily done.
Good to see that.
Got the stalwarts here.
Yeah.
So, okay. I've just done it before then.
I didn't notice that there.
Oh, there's a front page, that's why. Right. Okay.
Something's doing my little announcement thing because it's catching up.
So you're up here first?
No, you.
Oh, where are you?
I'm staying right in the middle.
Oh, so they can't see you though. I don't be able to see you.
Yeah, well,
Camera.
No, we'll just stand in the middle of it.
Oh, you're gonna, yeah, okay. Okay.
This technology on this board is fantastic. I've never seen it until last time we were here.
No, one actually they have a user for it. That's why when I clicked on it, it had all the writing I've done. Yeah.
You just write on it?
With a special, you can.
With a special.
You can use it connects it as a whiteboard. So the other one, in the option room, they use the mark like you say, the whiteboard. Then I would try. Yeah. I think that's done.
Yeah.
Well, Greg, I mentioned last week we could email you to get the presentation notes.
Did you email?
No, I forgot. Just only remembered a moment ago, so best I make a note.
Okay.
Well, welcome along to session 2 of our spring series. Today we're very fortunate to have Elizabeth Rabier, our Harcourts New Zealand legal counsel, and Elizabeth's going to be presenting today on essentials of leasing. Sorry, essential elements of leasing. Better get that right. Elizabeth is a very experienced commercial lawyer. Across her desk over a number of years, she's seen an awful lot of agreements, and it'd be fair to say that not all of them are perfect. The intention today is to provide information and knowledge that will help you to prepare lease agreements and deal with lease documentation to avoid some what could end up to be some costly mistakes of unintended consequences. As with session 1, where we concentrated on how to make more money, you can actually construe this as being how to hang on to that money rather than have to wear the costs of silly mistakes. Now, to be clear, the presentation that Elizabeth is about to give is not to be construed as legal advice. It's based on New Zealand documentation, and if you are viewing this in another territory or market, please be aware that there might be legal terms, definitions, and requirements that differ from those that are going to be delivered today. Now, if you have any queries on that may arise from the information today, there will be a time at the end to ask questions. But if you go away from here and you think of legal questions, or if you're working on an agreement and you have some legal questions, those queries need to be directed in the first case to your manager or business owner, who will send them through to me, and then we'll decide on how to deal with it from there. Unfortunately, due to Elizabeth's heavy workload and responsibilities, she's unable to deal directly with salespeople on legal matters. Without any further ado, I'll introduce Elizabeth Rabier, and I think the information she's going to get through will be worthwhile for us all.
Thank you, Greg. Hello, everyone, and thank you for attending. So, as Greg said, essential elements of leasing. So, to begin with, I thought we would start with the documentation. So, we're all aware and familiar with the agreement to lease. The current form of our agreement to lease is the edition 2012 version 3, which you will see at the top right-hand corner of the agreement. Now, when parties sign the agreement to lease, they agree to enter into the most current form of the Auckland District Law Society Deed of Lease. As well, the parties will be bound by the terms not only of the agreement, but of the lease, regardless of whether or not they've actually signed the lease. The next document that we normally deal with in our leasing is the deed of lease, or that we should be familiar with. And again, the current form of our deed of lease is the 6th edition 2012 version 4. Now, I'm just going to work through the agreement to lease and look at the different elements that we see in our agreement to lease. To begin with, the address of the premises. Insert the actual physical address at the top of the page there, because that's one of the ways of identifying the correct premises, so that all the parties are aware that the premises that you are signing up for, they can check the address, and it is quite clear what you're talking about. So moving down, we're looking at parties, landlord. To help you identify the correct landlord, I think it always pays to get a copy of the certificate of title for the premises, and that way you will ensure that you have got the right registered proprietor and that that person or those people will be signing the agreement to lease as landlord. Next party, the tenant. So if the tenant is a company, I always get a company search from the company's office so that I know who I'm dealing with and who the directors are, because the directors should be the people signing as tenant. And if it's a trust, then ideally you would want to cite the trust deed to ensure that you have all the trustees signing the agreement. And also we have the guarantor, and in the usual circumstances, if the tenant is a company, the shareholders will be required to sign as guarantors. In relation to a trust, if the tenant is a trust, the trustees should sign as guarantors in their personal capacities, and it'll be very unlikely that any independent trustee would sign as a guarantor. Now, further to parties, under clause 1.4 of the agreement, the liability of the parties is joint and several. As well, if the agreement is signed up for provision of a nominee, the tenant under the agreement to lease remains liable until the nominated tenant and the new guarantor sign the lease. Please note also that when you are signing a trust as the tenant, please point out the trustees' warranties in the contract, as they should be aware that they are warranting certain things. For example, that they have the authority to sign and bind the trust to the contract. As well, in terms of trusts, there is a limitation of liability for the independent trustee, and that should also be pointed out to the independent trustee. Moving on to the actual execution of the agreement to lease. Pointing out the obvious, but you have I've had agreements to lease pass my desk where one party has forgotten to sign. And that worries me as being a lawyer, because it's all about binding the parties and being able to enforce the agreement against those parties. So very important that you check that everyone has actually signed the agreement. In relation to guarantors, again, can't enforce the obligations of the tenant against the guarantors if the guarantor doesn't sign. And as well, in the deed of lease, there are provisions for the witnesses to complete their part. Now, with many occasions, and I've been asked, what if Mr. X is not available, but there are 3 trustees? Well, until that Mr. X has signed the agreement, again, as I said, very hard to be able to enforce against the trust or the other party if one party has not signed. So if the party is not present or cannot make the signing of the agreement, then if you cite a written authority for Mr. X to sign on that person's behalf, then that should be sufficient to bind the trust or the party missing. Also, counterpart copies are now acceptable in relation to the agreement and the lease. So moving on to sit, starting with the premises. Ideally, you want to describe the actual premises, for example, part ground floor, the square meterage, if there's a shared lobby, and what the title reference is. I also like to attach a plan of the premises, again, to ensure identification of the correct property. Now, there's been a recent introduction with the 6th edition of the deed of lease, and that premises now is defined as including the landlord's fixtures and fittings. So please be aware of that. Another matter I discuss with my landlord clients is it is quite important I think it's quite important to take photos or film the condition of the premises prior to the leasing. And that is evidence of the state of the premises at the commencement date, which will be very useful and valuable to either party at the end of the lease. Moving on down to car parks. I like to point out the location of car parks to the tenant, or have the landlord point it out, because I've had situations where retail tenancy looks great. Unfortunately, car parks around the corner. Tenant not happy, tenant really wanted to get out of that lease. So it might sound a bit mundane, but actually it can later the track. Again, as with the premises, I always like to see a copy of the car park location, and if numbered, the numbers of the parks, and attach that to the group, again, easy identification. Moving on to the term. So generally speaking, longer terms are favoured by the landlord, and shorter terms are favoured by the tenant. Now I'm just speaking generally. Obviously it depends on what the situations are, but that tends to be the common practice. Commencement date. So Commencement date should be the date that the possession is given and taken, okay? However, and that includes for fit out. So if you've agreed for a fit out period, then whatever day that you've given possession, that you're giving possession, the landlord's giving possession to the tenant, that should be the first date of the lease. Again, rent holiday periods, the first day of the rent holiday period. Rights of renewal. So again, generally, rights of renewal for long periods are favoured by the landlord because they tend to add value when the landlord is thinking of selling the premises. Tenants, on the other hand, prefer shorter periods, but more rights of renewal, and that adds value to the tenant if they're looking at a possible sale of their business down the track. And please note that in relation to the landlord actually is obliged to renew the lease if there are renewals available, and conditions in clause 32.1 of the lease are satisfied. Deposit. Deposit is the advance rent. However, if there are conditions in the agreement, the agent should hold that deposit as stakeholder until the agreement is unconditional. Now, if the tenant fails to pay the deposit, there is a 3 working days notice in writing that's required to be delivered to the tenant before the landlord can cancel the agreement. And as well, the landlord actually is entitled to request default interest be charged if the deposit is late in being paid. Rent review dates. To save argument as to what the actual date is, we used to use references to 2 yearly and such like. Now the practice should be actual dates, insert actual dates. You can't argue with that. Okay, so moving on to rent reviews. As we're aware, there are now 2 types of rent reviews, and one of those types must now be specified. So the first type I'll discuss is the market rent reviews, and there is a limited ratchet in clause 2.1d of the lease, in that the rent cannot be less than the rent payable as at the commencement date of the current lease term. Now, under a market rent review, there's a 3-month notice period, which either party can give to the other, specifying the proposed annual rent. So that's actually one of the conditions or one of the terms under the market rent review. The other type of review, as we know, is the CPI rent review. And again, limited ratchet, this time in clause 2.5d of the lease. Now, I'm not sure if you're all aware, but under clause 2.5, the formula contained in that clause actually allows for market rent reviews in between the CPI rent review dates. Now, if your landlord wishes to have a different type of rent review, then the formula should be prepared by the landlord's solicitor and provided to you and inserted as a further term in the agreement to lease. Now, I'll just quickly run over the default interest rate. Previously, if you failed to put a percentage in, the default interest rate on the first schedule, then you're doing your landlord a disservice, and a lot of arguments could result from that omission. However, we now have a default position. So failure to insert a default provision, default interest rate in the first schedule is not the end of the world now, because we have clause 5.2 of the lease. Moving on to business use. So we know it's the tenant's obligation to check with council as to whether or not their intended business use will it be acceptable for the zoning that the premises is in. So you can make that a condition of the agreement to lease. And also it's wise for the tenant to check this out in any event, because if there is consent required, there normally are weeks of delays of doing certain works to be able to obtain consent from council. Now, the landlord can actually refuse to grant a lease if the business use is either in competition with an existing tenant, or it's unsuitable for the premises, or the business use is non-compliant with the Resource Management Act. Now, if there is a change in business use which causes an increase in the insurance premiums or extra premiums to be payable, or requires compliance with the Building Act, the landlord may, as a condition of its consent, require the tenant to pay the increased or extra premiums, or comply with the Building Act and pay the compliance costs. Now, not sure if you're all aware, but if you're leasing a retail tenancy, clause 16.3 actually puts an obligation on the tenant to have the premises open during usual trading hours. Usual would be whatever is usual in that area, I suppose, and fully stocked. So there is actually an obligation on the tenant in respect of running their business efficiently. Moving on to landlord's insurance, we all know that there's the general cover for the premises against damage and destruction. So you have the option of full replacement and reinstatement, or option B, indemnity to full insurable value. So that's an important discussion to have with the landlord, because it depends obviously on their policy, and if you fail to delete one or delete either of them, the default position is full replacement and reinstatement. As well, there are additional insurance risks that may be covered by the landlord if they so wish. The default period is 12 months, but again, that can be changed as well. And the additional risks may include such things as loss of rent and outgoings, destruction or damage of the landlord's fixtures and fittings, and of course, public liability. Now, in terms of payment of the insurance, the tenant under the outgoings is responsible for if the landlord makes a claim due to an act or omission of the tenant. The tenant is also responsible to ensure that the insurance policy is not made void or voidable, or cause an increase in or extra premiums to be paid because of something they have done or failed to do. And as well, the landlord's not required to cover any intentional damage or destruction caused by the tenant, or any destruction or damage due to an act or omission of the tenant occurred on the premises, and which may be an imprisonable offence. And lastly, if the insurance money is irrecoverable because of an act or omission of the tenant. In relation to premises in earthquake areas, the landlord should really have a discussion with their insurer in the first instance, because there may be clauses or further terms that the insurer would require the landlord to include in their lease. Now, in relation to standalone units in a unit title development, the landlord must insure the premises if the body corporate has resolved that the landlord must do so. So that's for the little standalone units. Now, in relation to no access periods, there's a little bit of confusion over what that entails. So if there's an emergency and the tenant cannot gain access to the premises because of a health or safety concern, then either party may give 10 working days notice to the other to cancel the lease. But that's only after the no access period, which the default provision is 9 months. So if you're acting for the landlord, ideally 9 months. If you're acting for the tenant, then likely a shorter period of time. But as well, if the tenant can argue with the landlord that they won't be able to have access at all during whatever the no access period has been agreed upon, then the parties can actually agree to an early cancellation despite the no access period not having been completed. Now, proportion of outgoings. Just briefly, if the tenant's leasing the whole building, then yes, 100% of all the outgoings associated with that tenancy. However, if it's a premises that forms part of a building, then ideally the landlord should give you the percentage that the premises actually equates to in relation to the entire building. And if the estimated, now we have an ability to include what the estimated outgoings are in the first schedule of the agreement and the lease. And if the landlord incorrectly calculated the proportion, then clause 3.2 of the lease now ensures that the landlord varies the proportion correctly. Now, moving on to the outgoings themselves. So in terms of cleaning, maintenance and repair charges, including minor repairs to the roof or charges for repainting, decorative repairs and maintenance and repair of building services, these are payable by the tenant. However, if the landlord has a service maintenance contract which the tenant is already paying for, then they will not be required to pay that twice. Now, in respect of charges for structural repairs to the building or repairs for defects in design or construction and renewal or replacement of building services, or charges for repaving or resealing yard and car parking areas, including costs of upgrading or other work to make the building compliant with the Building Act. These are not things that a tenant should be paying. That is the landlord's responsibility. Moving on to tenant maintenance and repair. So the tenant's obligation under the lease is to keep and maintain the interior of the premises in the same clean order, repair and condition as at the commencement date. So this is where the photos and the films will come in handy. Because at the end of the tenancy, the tenant must leave the interior in the same clean order, repair and condition. However, as we all know, the tenant is not liable for fair wear and tear from reasonable use. In respect of glass, that's to be repaired or replaced if broken. Doors, windows, light fittings and power points are to be repaired if they are damaged. In respect of light bulbs, tubes and power points, they are to be replaced if they are worn out. And in terms of painting and decorating the interior, that's only if the landlord reasonably requires you to do so. And again, with floor coverings, worn or damaged floor coverings should be replaced when required by the landlord. Any damage to the premises itself should be made good by the tenant. Additions and alterations. So if the tenant wishes to do make any additions or alterations to the premises, it must first obtain the written consent of the landlord. And at the end of the term, if the landlord so requires, the tenant must reinstate the premises. Now, if the landlord incurs any costs because the tenant has failed to reinstate, the landlord can recover such costs directly from the tenant. As well, any additions or alterations left by the tenant at the end of the tenancy can pass to the landlord if they so wish, without any compensation to the tenant. Now, when the tenant is thinking of undertaking any additions or alterations to its premises, obviously it must comply with the Building Act, and that's their responsibility. However, your landlord is the owner of the premises, so your landlord will want to keep an eye on the compliance under the Act. Now, at the end of the term, if so required by the landlord, the tenant is to remove its chattels and make good any damage, any holes, or anything like that. And again, if the chattels are left by the tenant at the end of the tenancy, these could pass to the landlord, or the landlord could take it to a refuse collection centre. Now, if the landlord is left to make good or to remove the chattels, again, the costs can be recovered from the tenant, and any loss that the tenant suffers, that's their loss, and they cannot look at the landlord for that. So that comes to the end of the essential elements of leasing. Thank you. Oh, okay.
Any questions in the room?
Yeah, I just had one. You mentioned briefly, Elizabeth, about the body corp situation with unit titles and requirements on landlords potentially short slice. So if you're signing up a lease on a body corporate situation, do you need to refer directly to the body corp to verify the landlord's responsibilities?
Yes, definitely.
Is that a bit like
Yes.
a pre-contract disclosure statement you're seeking?
Well, no, you don't have to go to that extent, but it's making inquiries. The landlord should already know what the status of their insurance is.
Sure.
However, having said that, I've many a time picked up the phone myself and made the calls.
Sure.
Yeah. So definitely do the homework, do the due diligence before, have all the information. Then at least both parties are very clear as to what is required.
Sure. I just had another question, if I can be greedy. Right at the very beginning, you made an opening statement about the deed of lease and the lease agreement, and made some reference to the fact that it's enforceable even if it's not signed.
The deed of lease,
Okay.
yes. So under clause 4.1 or 4.2 of the agreement to lease, it specifies that by signing the agreement, you are agreeing to enter into the current form, the most current form, whatever it may be,
Sure.
of the deed of lease, of the Auckland District Law Society deed of lease. And again, it states in there, in the agreement, that the parties are bound by the terms of the lease, despite the lease not being signed. And I've had a number of landlords where we have an agreement to lease and no deed of lease, despite me saying, let's get the deed of lease signed. So some people are happy with that. There is provision for it. However, I would recommend that the actual deed of lease, the current version at the time, is provided, because then the tenant knows what their obligations are moving forward. Yeah. Just in terms of helping the process, helping your tenant and the landlord seal the deal, really, and make the agreement unconditional. Hello?
You mentioned about the trust, like every trustee must sign. Similar business, same thing, or who? Does any one of the representative, the managing director, or the owner also have?
In respect of a company?
Yeah, like it's commercial.
The company that's entering the agreement to lease as a tenant.
Yeah.
Get the company search. It's online. It's free. You just go New Zealand Companies Office. Get the title of the company. Print it off. It'll show you who the directors are.
So all of them must sign?
All of them, unless they can prove to you that their constitution allows for one director and a witness.
And then what about the warranty again?
The warrant for the trustees?
No, for
The guarantors you're talking about.
Guarantors.
Guarantors. Yeah.
The guarantor's warranty. So what part was that? Sorry.
No.
Oh, no. You're concerned. I think your question is correct.
Yeah.
Circumstances, but you're asking about guarantors. Exactly the same. Unless someone opts out of being a guarantor and everybody agrees. So there could be a situation where you've got 4 directors of a company. One of them may be an accountant or an independent director. They may not be a personal guarantor, and that's up to the landlord's decision as to whether they allow that or not. But basically, everybody who's going to be a guarantor has to sign, and all the directors have to sign. And much the same, I think, if we talked about in other sessions and training, is that if you have a document that says, like on a family trust, that they authorise one trustee to sign on their behalf, but you need to have evidence of that, you need to attach it to them, because saying that. But I've got a couple of questions.
Okay.
And as much information, CPI rent reviews have become very popular in the last few years, and which is great. It takes away the unknowns for the tenant. They're pretty good over the length of a tenancy where the rent's going to be. Problem got a very low CPI rate for the last 2 years, might have been 1% or even less. So if you start off with a rent that's quite low to get somebody going into their premises, then the landlord can be stuck with low rentals for the length of the lease because they're not going to get that growth. So you've got to be aware of that when you're actually doing a lease as to whether as to the purpose of the CPI rent reviews, that you might keep it artificially low by doing that. You can actually alter the CPI rent reviews, so instead of just straight CPI, CPI plus a percentage. And you might see examples of it's CPI plus 2% every 2 years. I've seen ones where the rent was going up CPI, but with a minimum of 5%, maximum of 10% on a 2-yearly basis. So you actually have to look at those situations, and that's what Elizabeth was talking about, as to having the landlord solicitor perhaps draft that part of it. The rights of renewal, it's becoming more common for rights of renewal not to be granted. Rights of renewal, on one aspect, they might add a perceived value onto a tenant, onto an owner when they sell their property. But all the rights are with a tenant, not with the landlord. A move away from the rights of renewal will actually be to a longer initial term. And I've seen a number of clients who, instead of a tenant would come along and say, I'll take a 3+3+3 lease, where the tenant would say, the landlord would say, no, if you want to do that, you take a 9-year lease. Because all the options are at the tenant. If they perform the obligations of their lease, as was pointed out by Elizabeth, the landlord has to grant the right of renewal, but the tenant has the option. And I had a building owner say to me, I own the building, the tenant's got all the rights. They've got the option to walk away, I haven't. And they might want to change the use of it, redevelop it, sell it to an owner-occupier. So you've got to take that into an account when you're doing the lease. And examples of that where I've seen where 4-year lease, and if we're both happy with one another, we'll talk about extending it. Those sometimes you're not doing anybody a favour, or not doing the owner a favour or landlord a favour by actually adding on rights of renewal. So just think about that when you're doing it. Something else I noticed in insurance excess, and I've only ever encountered this once, but if you're dealing with big companies, it could be a concern. A property I was dealing with, I saw on the lease, the insurance excess was $500, and some of the older, the limit on the insurance was $500. A lot of existing leases, that's what the insurance excess was, and now the standard default position in the deed lease or agreement to lease is the tenant is liable for an excess up to $2,000.
That's right.
But on a lot of commercial insurances, the excess can be a lot greater than that. So you actually need to know what the landlord's excess is when you're doing that agreement. And an extreme example I encountered was where a major company, big global company, had the right in their lease to actually arrange their own insurance. And it was done under a blanket policy right across New Zealand among all their plant and equipment. In the lease, it said that the excess was limited to, that they were liable for, was for $500. But on their insurance policy, their excess was $2 million. So effectively, this property that was worth around $3 million, if it burnt down, somebody had to front up with $2 million for the excess. And under the terms of the lease, that was the owner. So effectively, he was uninsured. Now, he was never aware of that. So he had to actually go out and get a policy that insured him against that excess, which was quite expensive and quite difficult to find, and then had to renegotiate the terms with the tenant. Now I've only ever encountered that once, but that's some of the traps that you could fall into. And if you've got it signed up without being aware of what those insurance requirements were, that could come back to bite you awfully. So what I guess the message that we're getting here from today is there's a whole lot of technical terms which seem to be quite obvious, but you've also got to look at some of the details and just make sure you've got it 100% correct. Because once it's signed, once everybody's signed it, you've got a signed agreement, and there's no obligation for either party to agree to change it once it's signed. And in that case, those 4 little letters REAA might pop up, and we might get any other questions?
I'd just like to add to that, thanks Greg. So if you are signing up an agreement and there are things that you yourself are not totally sure about, it might pay to have that discussion with the tenant as to whether or not they need to do some a special provision, due diligence or something like that, just to ensure that both parties have actually got all the information correct before proceeding down that route. As Greg said, once you've signed it and it's unconditional, and you've got the insurance completely wrong, it's those things that are going to really upset one of the parties and hopefully not your landlord. So big discussions before racing off and getting the agreement to lease signed up.
I guess one thing before we finish is rent-free periods. We didn't cover that. Elizabeth and I had a discussion earlier of how they should be structured. We disagreed, but mine I thought was a bit more practical, but Elizabeth was actually technically correct. So, and what I'd done in the past was actually allow free access. So, if you were going to start, let's say for example on the 1st of September, a lease, but you were actually giving 2 months rent-free, what has been a common practice is actually to make the commencement date of that lease 1st of November and give the tenant free access to the premises. That way you didn't dilute the length of the initial term of the lease, and a valuer wouldn't look at the lease and say you had to give the tenant an incentive to go in there, so we're going to devalue the building and change the yield on that price, on that basis. Elizabeth tells me I've been doing the wrong thing for a long time, and that's the difference probably between an agent and a lawyer. But this version of it is that we should actually to September in that situation and allow that 2 month rent-free period, because then they have to meet the obligations of the lease. They have to meet requirements. If they damage the building, they're still obligated to raise. I actually understand that, why you're doing that. It actually makes a lot of sense. And if you weighed it up on balance, my area of operating, which would have been the free access, might have had a benefit to the landlord or the building owner at some stage down the track. But I'd also suggest that the liabilities, what could go wrong, would outweigh that. So.
And also to add to that, normally a rent-free period is negotiated, but there are other things like outgoings which have not been agreed upon. And so for me, the commencement date is always the date you give possession. So then the tenant is locked into the obligations under the lease, the normal obligations as if they were, started and opened up shop. And it protects the landlord. The outgoings are paid. They've got a responsibility to pay the outgoings, because normally if it's, for example, a refit, a couple of months to do the refit, they've taken possession 2 months earlier, but they're using the power, the water and everything, so they should be responsible and pay for that. So the negotiation was to do with rent. It wasn't to do with insurance and outgoings and things like that, and legal responsibility in terms of building with the compliance with the Building Act, those sort of things which are all covered in the deed of lease. So that's where we differed.
Yeah, and if you had a situation where the tenant was going to go and pay no outgoings, Elizabeth's argument still stood up, that you still made the commencement date 1st of September in that scenario, and it was written into the lease that they weren't responsible for any of the outgoings. So they didn't have a financial cost in there, but they had the liability of if something went wrong, they had to comply with the Building Act for the work they were doing. The tradespeople had to do a good job and all the rest of it. So I defer to my learned colleague here, and she was right.
Thank you, sir.
Now, I think that winds up our session for today. Just a reminder that next Friday our session is moved, not next Wednesday, it's next Friday, it's 11 a.m. and Richard Leary will be here from Australia to talk to us on presentations. So I'm really looking forward to that. Hopefully as many of you can make it along here as a live audience again as possible, and thanks for your time.
Thank you.
And thank you to Elizabeth.
Thank you.